Yeah.
So embarrassing.
So did you freeze during the tour? Oh,
Blue Angels. Great. I learned so much about Myra was on our leading tour. I was her, you know, to help. She gave me the tour. She gave me the tour as well.
Because she like never connected that I went here for undergrad and was a tour guide.
Okay.
So she just thought I was this insane person that just looked at all these random facts.
The most enthusiastic one I've ever.
I kind of name tagged. I'm sorry. I was in Google settings. Now I'm actually interested. I'm gonna look up the sundial and see if I can find that. I'll email you if I figure it out.
Yeah, let me know.
I'll put it in the MMU.
You should.
I would say really.
Oh yeah, it's a long story. It's just like that's why
Ruben, that was the best story.
oh, I know. I'll have another one.
A reenactment.
I know. Absolutely not. Well, you know, because I came in here. First time. Me neither. And you go for it. Like yesterday, I ran 5 minutes. After 6 miles. I hope so. 2.5 They're identical.
Oh, okay. Shake your hand. That's okay. $105. I think it's at 8:30, so wrap it up on like 2 more.
We are going to get started now. So, hello, my name is Susan Esquivel, and I'm a second-year law student and co-president of the Hispanic Law Students Association here at Notre Dame. I first want to thank you all for coming to the 2015 Graciela Olivarez Award Ceremony today. For those who may not know, today's award is named in honor of the first female and first Hispanic to graduate from Notre Dame's law school in 1970. Graciela Olivarez was born in the segregated mining town of Sonora, Arizona during the Depression. Her father was a machinist who worked in the copper mines for 35 years and emigrated from Spain to the United States. And her mother, a Mexican-American, gave piano lessons to help support Graciela and her 4 siblings. When Graciela was only 15 years old, she was forced to drop out of high school and find a job to help support her own family. After her parents divorced, Graciela moved to Phoenix, where she grew up in a community where certain forms of legal discrimination were still practiced. Graciela's interest in civil rights was first sparked by her work as a host of an Action Line radio program, giving her an opportunity to hear about the complexities of racial discrimination from her Chicano audience. Later, Graciela would be appointed to the head of the Arizona branch of the federal government's Office of Economic Opportunity. It was also around this time where Graciela would meet our very own Father Theodore Hesburgh, who had been appointed as the director of the United States Civil Rights Commission. Impressed by her intelligence, service, and compassion, Father Hesburgh encouraged Graciela to enter law school at Notre Dame. Despite lacking a high school diploma, despite being 39 years old, much older than many of her classmates, and despite having a 7-year-old son at the time she entered her class at Notre Dame. Having recently spent a lot of time reflecting on Father Hesburgh's life and legacy, I would be remiss not to say thank you to Father Ted for opening up the doors of Notre Dame Law School to women and to Latinos. At dinner last night, Professor Gurule was speaking of Father Ted's many little acts of grace, and how fitting that Graciela's nickname happened to be Amazing Grace. As we continue to celebrate Father Ted's legacy and many accomplishments, I am happy that Graciela Olivarez and this award is a part of that celebration and his legacy. During her time at Notre Dame, Graciela certainly had many obstacles to overcome as a result of her status, being one of only 2 females in her entering class, most likely the only person of color in her class, as well as being taught by an all-white male faculty. However, this award is not only in honor of her graduation from Notre Dame Law School, but it is a recognition of all she accomplished afterward. After graduation, Graciela moved back to Phoenix, where she worked as a consultant to the National Urban Coalition, and then as director to an OEO-funded program designed to improve federal food programs in the state of Arizona. She then moved to New Mexico to serve as the director of the Institute for Social Research and Development at the University of New Mexico, and as a professor of law at the University of New Mexico Law School in Albuquerque. In 1975, Graciela was appointed the secretary of the New Mexico State Planning Office, where at the time she served as the highest-ranking woman government official in New Mexico. As Graciela's reputation grew as a civil rights leader, she was appointed to serve on the board of directors of the Mexican-American Legal Defense and Educational Fund, MELDA. Along with Vilma Martinez, the two were the first 2 women to sit on the board, with Vilma later serving as president of the organization and Graciela as chair. In April of 1975, Graciela was named by Red Book magazine as one of 44 women who could save America. And in 1977, President Carter appointed Graciela to serve as the Director of Community Services Administration, the federal government's anti-poverty agency. Graciela was unanimously confirmed by the Senate, becoming the highest-ranking Hispanic and 3rd highest-ranking woman in the Carter administration. And her work with the CSA earned her the title as Washington's top advocate for the poor. Graciela's awards and honors would be far too long to mention them all here, but later in her career she would receive a number of honorary degrees and serve on a number of boards. Just to highlight some of her biggest achievements, Graciela was appointed to the National Advisory Council on Economic Opportunity by President Johnson, and then later appointed by President Nixon to the Commission on Population Growth and the American Future, where she later served as vice chair. During her entire career, Graciela always found time to volunteer her talents and skills to the most marginalized. It is easy to be in awe of the many accomplishments that Graciela achieved, especially considering that Graciela's life was tragically cut short by cancer. However, I think our call as lawyers and citizens is not only to be in awe, but to be inspired by her achievements. To feel responsible in the way Graciela did, to use our own opportunities to improve the opportunities of others. To recognize our own privileged education, and to use our time and talents to advocate for justice and create positive change in the lives of the most marginalized. So it is only fitting that our honored guest this afternoon has spent his entire career fighting for many of the same causes that Graciela did. I am honored to introduce our award recipient today. Thomas Saenz hails from Southern California, though he headed out east for his education, graduating summa cum laude from Yale University and later earning his law degree from Yale Law School. After clerking for both the U.S. District Court for the Central District of California, as well for the U.S. Court of Appeals for the Ninth Circuit for the Honorable Stephen Reinhart, Thomas began his legal career at the Mexican-American Legal Defense and Educational Fund. As a civil rights litigator for the organization, Thomas spent 12 years fighting for immigrants' rights, educational equity, employment rights, and voting rights. Among his many achievements during that time at MALDEF, Thomas Saenz initiated the employment discrimination lawsuit, which resulted in a $50 million settlement with Abercrombie & Fitch, as well as served as lead counsel to challenges against California's redistricting in 2001, and twice as MALDEF's lead counsel against California's English-only education initiative, Proposition 227. Following his time at MALDEF, Thomas spent 4 years serving as counsel to Los Angeles Mayor Antonio Villaraigosa, where he helped to change the governance of the Los Angeles Unified School District, and served as lead liaison in labor negotiations with the city's workers, before ultimately returning to MALDEF. As president and general counsel of MALDEF, Thomas leads the historic civil rights organization's 5 offices in advocating through litigation, policy reform, and community education. With a busy, if not never-ending docket of issues and cases on his plate, Thomas continues to pursue positive change for some of the most marginalized communities in our country. His commitment to justice is not only shown through the number of boards he has served on, nor the numerous awards he has received, but rather it is most demonstrated in his career-long persistence in providing hope through legal services and change through legal advocacy, in an area of law that often goes unrewarded and can seem like an uphill battle. In my opinion, Thomas Saenz is a lawyer who was cut from the same cloth as lawyers like Graciela, and exactly the type of lawyer our Notre Dame slogan promotes, a different kind of lawyer. Please join me in congratulating this year's Graciela Olivarez Award recipient, Mr. Thomas Saenz.
Thank you, everyone, and thank you for being here. And I want to thank the law school and the Hispanic Law Students Association for what is truly a deep honor. It is a deep honor in part because of what you've already heard. Graciela Olivarez was a part of MALDEF's initial history as well. She was one of the first 2 women to serve on MALDEF's board, together with Vilma Martinez, one of my predecessors and my #1 professional mentor throughout my career, ongoing. And she was Graciela was the first woman to chair the MALDEF Board of Directors. So she played as much of a role as anyone in establishing what is now a 47-year-old organization continuing to work to promote the civil rights of all Latinos living in the United States. And obviously her ability to make the contribution that she made to my organization was enhanced tremendously by the step that Father Hesburgh took in seeing that she would be admitted to this law school and complete law school here and make contributions that she made across the board. So it truly is an honor, and an honor that I attribute to the work of the entire organization. It's been my great honor for almost 6 years to lead a staff of courageous attorneys and non-attorneys, community educators, policy advocates, support staff in working to ensure that the growing Latino population, as you all know now, the largest minority population in the country, that the rights of Latinos of whatever status are protected, and their ability to engage in civic endeavors, to engage in economic development, to engage in contributing to the growth and continued thriving of our nation is enhanced through the legal system. Recognizing that this award in my name is really an award to the entire organization, I would be remiss if I did not recognize the MALDEF board members who are here today and who have made tremendous contributions from the board in ensuring our continued ability to deliver the strong services that my colleagues deliver on a daily basis across the country. First is Gil Cardenas, who has been with MALDEF for so many years that I won't say how many years. I'm not sure I could identify the number of years, but he has contributed throughout our history, not only through board service, but as an expert witness and a consultant on a number of the important matters that the organization has undertaken over the years. And my friend Charlene Aguilar, who is our most recent chair of the board, following in the footsteps of Graciela Olivarez as a dynamic woman leader of the board of directors. I do have to say, as a slight digression in this regard, that I'm very proud to lead MALDEF, but I'm also proud that for 29 of the 47 years of our existence, MALDEF has been headed by a woman. Through 3 presidents and general counsel who were women, the vast majority of our existence and our success today owes itself to the leadership of those women, as well as folks like Graciela. As we approach our 50th anniversary, it presents an occasion to reflect on what MALDEF's mission is. And as I said, our specific articulated mission is to promote the civil rights of all Latinos living in the United States. But that only touches the surface of what I believe we do and what our ultimate goal is. Just as Graciela was a trailblazer here at Notre Dame Law School as one of the first 2 women to attend, and as and certainly the first Latina to attend and to graduate, I believe that MALDEF's role is to blaze a new path in the area of civil rights jurisprudence. And this is the right time to discuss that, because not only the demographic growth of the Latino population and its dispersion throughout the country. When we were founded in 1968, it could fairly be said that the Latino population in this country was regional, in the Southwest from Texas to California, with pockets of significant population in Chicago, New York, and South Florida. Today, 47 years later, it's quite clear that Latinos are a national minority group with significant numbers in every region and virtually every state of the country. That clearly has an effect on our public policy debate, as anyone who turns on media of any kind today would understand. So many of the critical issues being faced and debated, sometimes responsibly, sometimes not so responsibly, by our elected leadership, center around the Latino population. And so our work in MALDEF centers on some of the most critical policy issues faced nationally. And the 4 programs that our board of directors has for many, many years assigned us to be involved really are critical to the future of this country. Employment, education, immigrants' rights, voting rights. But truly our endeavor is about changing the law. We work at the cutting edge of the law, as we say. Our goal is to change the law. And today I'd just like to highlight 2 parts of that in this law school setting. Just as Graciela was a trailblazer here, I'd like to talk about the trail that we try to blaze at MALDEF. You could call these 2 elements of a Latino jurisprudence, developing area that would have our constitutional jurisprudence in this country go in a somewhat different direction than it has historically. One piece of it, the central piece of it, really grows out of the entire history of the Latino community with the United States legal system. Our first Supreme Court case in the Latino community involving discrimination against our community was in 1954 at Hernandez versus Texas, and it epitomizes what I am about to describe. It was a case in which the Mexican-American plaintiff was challenging the exclusion, long-standing pattern in Texas, of any Mexican-Americans from his jury. And that was, in fact, the long-standing practice. There was a case 18 years previously involving the African-American community and its exclusion from juries in the South that the Supreme Court had decided and set up a test to determine whether there were sufficient indications of a constitutional violation in that jury exclusion. In that test from Norris versus Alabama, you didn't have to prove any intentional discrimination, didn't have to find that smoking gun evidence. All you had to do was establish a long-standing pattern of no one from the African-American community serving on the jury or any jury in a particular jurisdiction. And Latinos in Texas, taking that precedent from 1936, sought to apply it to their own situation where Mexican Americans were routinely and regularly excluded from juries, both grand juries and petty juries. But they ran into an obstacle. Specifically, the state of Texas craftily decided that Latinos were a part of the white race, not at all established prior to that point, but craftily they started to describe Latinos, Mexican Americans in court, as part of the white race, and therefore argued that that exclusion rule from Norris versus Alabama didn't apply to them because they were white, and lo and behold, every jury that they had was all white, though, of course, none of them were Mexican American. So through that change in terminology, the state of Texas sought to deprive the Latino community in Texas from using that Norris versus Alabama rule. The result, fortunately, was a unanimous decision by the same court that decided Brown versus Board in the same year, concluding that if you treated a social group as different, didn't matter whether you characterize them as being of the same race as the majority or not. If they bore all the social markers of a distinction, then they could call upon that exclusion rule in challenging long-standing patterns of jury exclusion. But Hernandez versus Texas is really very much a case about trying to devise and apply tests and frameworks from the law that were developed for the related but different circumstances faced by African Americans and applying them to the Latino community. And I would say it epitomizes the struggle throughout the remaining years of the Latino community in civil rights law. That is, we have throughout our history had to attempt to ensure that those tests and frameworks devised for the African American community could be used by Latinos facing discrimination. So that in particular is seen as we have struggled in the Latino community with discrimination by proxy, where folks hide their discrimination, which is clearly race-based. Those who would study it, who would evaluate it, indeed anyone with familiarity with the social context would conclude that it is discrimination based on race, but it's often in the guise of discrimination by proxy. We're not discriminating against you because of your race, but because of your language, or because of your citizenship, or because of your immigration status. And you can add other proxies to that list. It is a demonstration of the struggles that the Latino community has faced in applying civil rights law that was devised for related but different sets of circumstances. So Latino jurisprudence is really about arriving at a set of laws that doesn't face that flaw, that anticipates the future kinds of discrimination that anyone in the nation would face, and anticipates them by preventing what the state of Texas attempted to do in Hernandez versus Texas, preventing a change in terminology, change in explanation, from somehow denying the protections that were intended by our anti-discrimination laws, beginning with constitutional provisions and extending through the civil rights accomplishments of 50 years ago in the 1960s. That's what I think MALDIF is about. It's about trying to arrive at a set of civil rights principles and the laws that will not only serve the circumstances of today, but will anticipate future examples of discrimination by proxy, future examples of hiding racial discrimination behind some other guise. Corollary of that, and the other principle that I would discuss today, is our efforts at MALDEF to ensure that our notion of civil rights laws, civil rights provisions in the United States Constitution is always broadened. Throughout our history, particularly in the last 20 to 25 years, a lot of MALDEF's cases have not been brought under the Equal Protection Clause of the 14th Amendment, which directly prohibits discrimination on the basis of race or national origin. Instead, our cases have come under clauses of the Constitution like the Supremacy Clause, which is how we have challenged since Proposition 187 California, where I got my start at MALDEF, how we've challenged all of the anti-immigrant laws throughout the state from Proposition 180, throughout the nation from Proposition 187 up through Arizona's SB 1070 and its replications in other states, including this one. But when I was in law school, and that was 25 years ago, we would not have conceived of the Supremacy Clause as a civil rights provision in the Constitution. But it is now a bedrock principle not only for MALDEF but for others who are engaged in challenging these anti-immigrant laws. In addition, we have pursued claims under the Contracts Clause of the Constitution that prohibits states from impairing contracts. We've used that to challenge anti-immigrant attempts in Proposition 187 to prevent university students from continuing to their degree completion. We've used it more recently in amicus curiae briefs trying to prevent the state bars from denying the admission of undocumented lawyers who've gone to law school in the state, in many cases to public law schools, completed their program, received their Juris Doctorate, and then face a potential denial of admission to this very state bar of the public law school that they attended. So we've used that Contracts Clause, and I guarantee that even today, there is not a law school in this country that would teach the Contracts Clause as a civil rights provision of the United States Constitution. And finally, we have used on a number of occasions, including in those cases challenging the attempt to bar lawyers who are undocumented from being admitted. We have used in a number of cases the 10th Amendment, which many would have characterized 50 years ago as an anti-civil rights amendment because it is the states' rights amendment. It is the portion of the Bill of Rights that protects the rights of states in comparison to the rights and authorities and powers of the federal government. But at MALDEF, we've used the 10th Amendment to achieve civil rights means in cases where we felt it was appropriate. And I have said in other occasions that I'm looking for the Takings Clause case that will promote civil rights aims. And I can imagine how it could be used to challenge any number of laws that would seek to deprive immigrants who have established businesses from being able to continue those businesses as a result of their status as undocumented. And again, I don't think there's a law school even today that would teach the Takings Clause as a civil rights provision of the Constitution. So that's a corollary part of what I have articulated previously, part of the Latino jurisprudence that I think at MALDEF it is part of our deeper, longer-term mission to establish that we reach a point where we see all of the Constitution as designed and able to promote civil rights, equality, and anti-discrimination principles, to a time when we are able to put in place laws and use those constitutional provisions to not only address the situations that led to the enactment of the laws, whether it was 50 years ago or the amendments that we need today, but that we can expand the application beyond the present and the circumstances that directly led to enactment to protect against anticipated future discrimination. For us today, it means that more and more of our work is challenging not discrimination on the basis of someone being Latino, but discrimination on the basis of gender or sexual orientation or disability or illness, but where we believe that the discrimination which comes under that label is targeted particularly at someone who is Latino or an immigrant or who faces some of the other traditional markers of distinction in the Latino community. So at MALDEF, some would characterize us as, today, an old-style civil rights organization, and some would even go on to argue that these old-style civil rights organizations are no longer relevant and no longer needed. But that's certainly not how we at MALDEF today see the organization. We are an organization that has certainly evolved and changed over the years But the consistent thread, in my view, has been about not only promoting the civil rights of all Latinos, but working more deeply to change the jurisprudence of the nature of the entire nation to be consistent with the principles that I've described. So on behalf of that organization, still after 47 years, I can say that as someone who's approaching his 49th birthday, still vibrant at 47 years, and still changing and evolving, and still playing a crucial role. And on behalf of the organization, I am deeply honored as we look to establish a different kind of law to accept this award that is named in honor of a different kind of lawyer who was a trailblazer like Graciela Olivarez. Thank you.
Before we let you sit down, why don't we see if any of the students have any questions, and have a brief Q&A session, and I'll seek to moderate. So if anyone have any questions that they'd like to ask Mr. Saenz?
Doesn't have to be related to what I said here. I answer all questions. I make up answers if I don't know them.
Okay, Ruben?
So you worked out with me, Mayor Villalobos, on the governance change at the LA Unified School District, and Latinos are still the least represented minority group in the legal profession. A few years ago, the Washington Post wrote an article saying that Latinos in the United States could be the first immigrant group not to surpass the education level of their parents. And research has been coming out of Stanford University that high-achieving but low-income Latinos are not even applying to top-tier institutions. So given that there's a lot of work to be done on, I don't want to call it low-hanging fruit, but in a way, it kind of is. These are probably things that are quick to, we could make a huge impact on. Where do we go kind of from here?
So first let me clarify, we did not succeed in changing the governance of LAUSD. We got what I think was very good legislation, only to be struck down by the State Court of Appeal. And I want to tell you why I believe that governance change was important. One of the flaws in our public education system today, and there are many, and I'm going to talk about one of them in a minute in response to your really good question. But one of them is that the structure of electing school board members in many, many districts across the country, particularly in large urban districts, really doesn't serve the Latino community very well. And that is because too many Latino parents, those with the greatest investment, if you will, in the success of local public schools, cannot participate meaningfully in elections. For some, it's because citizenship, the lack of citizenship, is a barrier to even casting a vote. And for many, many others, even if they are citizens, they don't have the financial resources to affect significantly the election of candidates of their choice. That's layered on top of some of the other structures, including at-large elections, that are a deeper problem not only in school boards but cities and even some counties and special districts across the country. So there is a problem when the largest minority group in public education cannot successfully use the existing mechanism to achieve equity in education, because that existing mechanism is the election of local school board members. And that's a problem of nationwide scope. And so we have been arguing, as we move closer to reauthorization of the main federal legislation on education, the Elementary and Secondary Education Act, that we have to have parental involvement as a critical pillar of federal monitoring and federal intervention. So what we have advocated for, and I've advocated for as part of the Equity and Excellence Commission that was appointed a number of years ago by Secretary Arne Duncan, is that the federal government ought to create a parental involvement index. And the vast majority of school districts across the country, suburban school districts, would easily surpass a floor on that parental involvement index, because you would be looking at things like, are parents on the school board? What kind of role are parents playing in the election of school board members, both as voters and as donors of what it takes to be elected? You would be looking at whether there is a transparent and fair process for parent representatives to be selected by their peers to serve on site councils and on advisory councils, and you'd be looking at whether those parental advisory boards have real power and authority. And once you set up an index like that, the idea would be, if you don't hit that floor, federal government needs to intervene. to make sure that there's meaningful parental involvement. That's only part of the solution to this very serious problem. The education gap has been long in existence, and we're not making enough progress in closing it, just as the Latino community in particular is growing in size. Close to 1 in 4 public school students nationwide is now Latino, and it's only going to get higher. So as we talk about the Elementary and Secondary Education Act, we also talk about 2 other pillars. We need, first of all, overarching all of this, the Elementary and Secondary Education Act was an element of civil rights legislation in the 1960s. When it was enacted 50 years ago, I think in a few weeks it's the 50th anniversary of the ESEA. So we have to put back at the center the goal of eliminating the education gap, because it hasn't been for a number of years. Instead, the public debate at the federal level, the national level in education has really devolved into a pitched battle between established insider stakeholders and the outside now stakeholders, because they're so well established in things like charter schools and voucher systems and the like. I'm kind of tired of that battle, and I'd like us to focus instead on eliminating the education gap. Recognize charter schools are a permanent feature of public education, but not a feature that's going to solve the entire problem. They will never amount to more than 10 to 15% of the student body, and put elimination of the so-called achievement gap at the center of federal law. But we also have to be serious in doing that about the 3 different pillars. One is we have to be serious about measuring outcomes and closing the outcome gap. And being serious means abandoning what No Child Left Behind did, which had 1 test, only to a basic floor of competency. And we've got to have multiple measures that look at achievement and education gaps from the highest levels of achievement all the way down, and in every different potential talent that is taught and developed in our public schools. So with those multiple measures and focusing on outcomes and setting real goals and monitoring of those goals to close the gap, we can be serious about this issue. The second pillar is we have to focus on resources and inputs, because we still lack equity across the country. MALDEF continues to litigate, including a case currently pending in New Mexico, one about to commence in Nevada, one that's at its tail end, but one of several every decade. We have to do it again in the state of Texas around specifically the issue of resource equity. Is the money, are the teachers, are the textbooks, are the facilities equal regardless of the student body and where those students live? And we're not there anywhere in the country. So it needs to be an element of federal law. And the third pillar is parental involvement that I talked about previously. Now, to enact all of this, we have to, as a nation, embrace a stronger federal role in education. And that's a tough pill for lots of folks to swallow, because of the way that we have almost fetishized local control in education in this country. There's an extreme reluctance to do that. But if we want to be serious about the national imperative of increasing educational achievement across the board, you've got to focus on the 25% of students who are Latino. You've got to focus on the additional 10 to 12% who are African American. We can't be serious about this as a national issue if we don't treat it as a national issue with a strong federal role. So I think there's lots to be done. And of course, behind all of this is what I've alluded to, which is at present, if you want to challenge these situations of education gaps, you're in state court, in front of state judges who are frequently elected, popularly elected. You're using state constitutional provisions, and that is not a strong or serious way of attacking the problem, because you're talking about having to establish 50 precedents, and if the state of Texas is any example, having to reestablish them every 10 years or so. And that's not a serious way of targeting and addressing this long-standing problem. Long-winded answer, but it was a good question. I appreciate it.
Any other questions? Anyone else? All right. One more question.
What impact do you think the growth of the Latino population is going to have on the work you do? What impact is having now, and what impact do you think it's going to have?
The growth of the Latino population? Well, I think it has 2 impacts. First, it really does place a greater demand on the services that MALDEF provides. We're an organization, unlike some others, that is based on a regional model. So we're currently in Los Angeles, San Antonio, Chicago, and Washington, D.C. We really need to be in the South, where we were for a time until the recession required the closure of the office. And we need to be in the Northwest if we're going to adequately, through a regional model, serve a national minority population like Latinos. So it's challenging. The demand is up. We don't have the resources to expand yet. We're working on that in partnership with our board of directors. But it also has the effect that there are other organizations that 10 or 15 years ago wouldn't have given a second thought to delivering legal services in the Latino community, who are now doing that. Some of whom do impact litigation in critically important areas. I think it's still very, very important. Perhaps it's an element of my organizational chauvinism. It's very, very important to have an organization like MALDEF doing a lot of this work, but we certainly welcome other organizations that are not identified specifically as MALDEF is with the Latino community to be involved in impact and direct services to the Latino community. And that certainly has begun to happen over the course of the last 10, 15 years and has accelerated. So from the more parochial perspective of MALDEF, it means there's more competition out there, but from the broader perspective of civil rights, that's a good thing to have more providers of these kinds of services. And that's entirely related to the growth of the Latino population and what that growth has translated into in terms of policy issues where that population is at the center.
Let me ask you a question. Do you have any advice for our law students, perhaps at this point in their legal career, have not decided what kind of law they want to practice? Why should they consider practicing either civil rights or the public sector? You've been involved. What advice would you give them?
Yeah, I hope that they will consider doing public interest work, and the primary draw to that, in my view, is not just that you can feel passionate about what you're doing, feel comfortable with the folks you're representing by and large, but also you get opportunities earlier in your career than otherwise might be the case, simply because we are stretched thin. So at organizations like MALDEF, we assign our youngest lawyers to leading roles in some of the critical cases, and that means that you get the opportunity to make arguments in court, to do the primary briefing of critical issues. You get the opportunity to take depositions and be involved at a central level in critical discovery issues earlier in your career than otherwise. I'll tell a quick story from my career. Proposition 187, which was this major anti-immigrant initiative passed in California in 1994 that would have, even beyond what SB 1070 in Arizona attempted to do 5 years ago, would have prevented anyone from accessing public services from school through healthcare through social services without being able to prove their legal status as either citizen, lawful permanent residence, or other legal presence. Very controversial. Every civil rights organization in California was ready to challenge it. MALDEF and the ACLU of Southern California were in the lead in a major case, ended up being the major case filed in federal court. I was at that point only a year into being at MALDEF, 3 years out of law school, was assigned a very small portion of the initial briefing on the preliminary injunction related to a procedural due process claim. The main claim, as I suggested earlier, was preemption and supremacy clause. But I had a small claim on procedural due process that actually was not devised to be its own standalone claim. It was actually devised as a terminal loop that would take the judge back to preemption, because the idea was if you provided the procedural due process required by the Constitution in denying people benefits on the basis of purported immigration status, the hearings that were required would be all about immigration and would be tantamount to deportation hearings that only the federal government has the right to conduct. So it was designed to get the judge back to preemption. So a lawyer of, at that point, 20 years out of law school from the ACLU, went through many moots, many practice arguments to prepare for the argument on the preliminary injunction. We got to court, or the TRO, don't recall which. We got to court, and the judge sent word out through his clerk that the judge was very interested in hearing about that procedural due process claim and wanted to make sure that it would be covered in the oral argument. Now, lo and behold, that very accomplished and very successful to this date lawyer at the ACLU was not prepared on procedural due process. He turned around and asked me in the courtroom, "Can you do the argument on procedural due process?" I had no choice but to say yes, because my boss, the then president general counsel, was sitting next to me. And so I said yes. And the time that he was arguing to prepare what I was going to say, got up and did well enough that my role in the case got larger and larger as time went on. But I guarantee you that would never have happened outside of public interest. I think that it would probably be impossible that would ever happen in a situation like that. So that's why I think, and I hope that folks will look at that as an option.
And let me recognize our Dean, Nell Newton, is here. So thank you, Dean, for joining us. We appreciate it very much. Well, Susan, I know, has a presentation that she'd like to give to us.
First, I'd like to thank everyone for coming and let you know that we'll be having a reception upstairs in the faculty meeting room with late refreshments. So if anybody would like to talk to Mr. Saenz upstairs, everyone's welcome to join. And then if you would all join me in congratulating Mr. Saenz on the Graciela Notre Dame song.
Thank you. Okay, well said.
And what's interesting is that some of the one of the recommendations that came up with excited
That is former Dean of Law School. I was thinking about that too. I was like, oh my God.
And did they tell me, I was listening to that, but I forgot to know where to law school.
Yeah.
Yeah. And are you in Los Angeles now?
Yeah.
I know there's a.
So one of the,
it's the faculty lounge, it's just on the left. You go up the stairs, it's right on the left. I don't remember. I mean, we call it the faculty lounge. You know, if I see you wandering, I'll go grab you.
I'll be right up.
The little mass are from my group, that family, races are from Mexico.
Okay.
It's not that bad.
we had focused, well, we focused, we on almost, yes, it gave us the interest in trying to do that, where we focus mostly so far.
But I bet you there's probably some
I
connection.
wonder, because I saw that, I saw that you were on the itinerary.
Mostly,
Probably, there probably is some connection, we're probably related cousins or something.
Yeah, probably.
Yeah, I would think so.
I have a cousin, we're gonna spend a week in June to kind of build a family tree.
Yeah.
Another cousin had done, we're going to shop.
Yeah, see, that's always exciting. Yeah, you bet.
Yeah, so
We're gonna go upstairs to the faculty lounge and, actually, if you just hold on a second, we'll escort everybody.
So you know my husband is.
Oh, you know.
And we're not talking about
I mean, you're chair of the board.
Well, I'm a recent
Past year.
We're a new chair. I'm going to chair that. Look, because office we lost them, things like that.
Talk about committees, those are committees that interviewed Gil.
Oh, that's really, yeah.
That's how long I've been here.
Long time.
So, and we were like, all right, let's gotta get us, gotta get us some lead
He
time.
came from, yeah.
He's from Utah, yeah, and Austin.
So we got,
So we're glad, and then I was on his advisory board for the institute.
Oh, great.
And so I think
Florida.
Yeah. I've known Gil 20-something years, more than Dolores has. Well, different, right? I've known her probably, she probably knew him
And you had dramatic results.
in younger days, because I was at the Stanford Center School of Research. And I was the associate director, and this was part of the small teams.
Yeah.
So Austin was part of that, a founding member, UCLA was a founding member, Stanford was a founding member, and then I think Sydney was, and then Florida International.
You probably know a colleague of mine, a long-time colleague of mine.
Not
Oh,
most.
I know Michael well, and Luis was like, I remember
Not with their
when I was in it, like,
Michael and I go back
It's
decades.
sort of like.
In fact, my name here is largely because of Gil's. I was president of the Hispanic National Law Association back in 1989. About that time, I was actually practicing law in Los Angeles. I was thinking about making a career change. And Michael kept, when I was president of HLSA, I established a law school.
1,500 so far.
committee.
So it's 20 years, so we have to
recruit more.
start small, keep
Latinos
growing.
into the academy.
Thank you so much for coming, that's a long trip from Los Angeles.
Oh, no, I'm glad to be here.
And so he kept telling me, you gotta do this, you gotta do this. And so Melvin came up here and he went ahead and promoted me. So.
Thanks,
Yeah,
Jerry.
nice to see you. Thanks for coming.
don't forget the red bag.
Okay, let's go upstairs. We've got, this is the invited recruitment student, so yeah. Let's go to the, let's go to the left.